The United States of America was the first nation on our planet, and as far as we know, the first in the entire universe to establish a democratic, secular government, committed to separation of church and state, as clearly expressed in the First Amendment to our Constitution, which begins, "Congress shall make no law respecting an establishment of religion." Not all of us remember the blueprints for our free society provided by our founding fathers. And so, Food for Thought Productions is pleased to present constitutional attorney Mr. Stephen Rhode with a remarkably clear and concise explanation of the evolution of our Constitution and Bill of Rights.
It's a pleasure to be with you today to talk about the dramatic story of the founding of the Constitution and the Bill of Rights. Some years ago, I was telling this story to a group of sixth graders, and I reached the point when I wanted to talk about the Bill of Rights and the First Amendment. I said to them that in my mind there was no coincidence that the Founding Fathers had placed the First Amendment right there at the top of the Bill of Rights. The First Amendment protecting freedom of speech and freedom of religion and freedom of the press. And I said that it was very important that we realize that the Founding Fathers placed such importance on the First Amendment. Well, a young man raised his hand in the back of the room, and very cautiously he said, "Mr. Rhode, I actually think that the First Amendment was originally the Third Amendment, and that when it was put up for ratification, the first two amendments weren't ratified, and so the First Amendment was really the Third Amendment." Well, I thanked that young man for his comments and asked him to sit down, but I went to the history books and I found out that he was absolutely right. So it seems to me that we all have a lot to learn about the founding of our constitutional democracy over 200 years ago. The Constitution we live under today was written in Philadelphia in 1787, but it was not the first U.S. Constitution. We all remember that in 1776, the Declaration of Independence was written. In the midst of the Revolutionary War, when American colonies were fighting for independence from England. And after a bloody struggle, we won that war and we established our independence. But at that time, we were 13 independent individual states, each with its own sovereignty. And they jealously guarded their independence. After all, they had just thrown off a despotic and tyrannical king in order to have their independence, and they were not interested in having that recreated in the American states. They functioned under the first Constitution of the United States, known as the Articles of Confederation. The 13 states were a loose confederation of states. There was no single nation. There was no national government. Simply 13 individual states. But that created problems because each state had its own currency. Each state imposed tariffs when people would move across state borders. And it was difficult in dealing in foreign relations because we were not a united states at that time. And so several founding fathers, James Madison, Alexander Hamilton, and others, recommended that a conference be held in May of 1787 in Philadelphia for the purpose of amending the Articles of Confederation. Some were very suspicious of what those men were about to do in Philadelphia in that year. Indeed, Patrick Henry, the great patriot of Virginia, refused to attend the Constitutional Convention. He said he smelt a rat. Well, 55 delegates did attend the Constitutional Convention from 12 states. Rhode Island was so suspicious they didn't even send delegates to that occasion. The delegates met in secret in Philadelphia. They didn't want anybody to know what they were up to. They wanted the peace and the quiet and the privacy of addressing the needs of our new nation. Indeed, they nailed up the windows and tried to keep everybody from listening in. They set about the business from May until September of 1787. And instead of amending the Articles of Confederation, they virtually threw the Articles out, and they rewrote a brand new Constitution and created a brand new form and structure of government. They created a strong national government with three branches which we have to this day: the executive branch, the legislative branch, and the judicial branch. Many compromises were made between the northern states and the southern states, between the large states and the small states, and they hammered out a final plan of government. By September, the delegates were exhausted. Only 39 of the original 55 remained. But one delegate, George Mason of Virginia, was deeply troubled by the Constitution that was emerging. The Constitution, by the end of that process, had no Bill of Rights. George Mason was very concerned at the absence of a Bill of Rights. By that time, every state of the Union had its own state constitution, and every state constitution recognized individual rights. Many of the state constitutions had declarations of rights. Mason should know he wrote the famous Virginia Declaration of Rights, detailing the individual rights of people as against the government. And so, in Philadelphia, Mason proposed that a Bill of Rights be written as part of the Constitution. It was ill-timed. The delegates were exhausted. They wanted to return to their families. Many compromises had been made, and many of them feared that if they opened up the question of a Bill of Rights at the Constitutional Convention, all of their other compromises might unravel. And so remarkably, voting by states, the Constitutional Convention unanimously rejected George Mason's plan for a Bill of Rights. In the end, George Mason refused to sign the new Constitution without a Bill of Rights. He said, "I would sooner chop off this right hand than put it to a Constitution without a Bill of Rights." Two other delegates joined Mason and refused to sign, but 36 delegates agreed and signed the new Constitution. But we still didn't have our Constitution because it had to be ratified by 9 of the 13 states. A huge national debate began over whether or not the Constitution should be ratified. It was far from certain. Groups formed into two camps. There were the Federalists, who believed deeply that to fulfill its dream, America needed a strong national government. And so the Federalists up and down the states argued strenuously that the state legislatures should ratify the new Constitution. But in every state, strong anti-Federalist feelings arose. People who prided themselves on their sovereignty and their protection from a powerful national government. That debate raged on. In Virginia, George Mason was a leader of the anti-Federalist camp. Imagine George Mason returning to Virginia and meeting for the first time with Patrick Henry. It was probably the loudest "I told you so" in history. Patrick Henry had feared exactly what had occurred. He had feared the creation of a powerful national government which would reduce the states to subservient subordinates, and in the doing would threaten individual rights. Patrick Henry pointed to the absence of a Bill of Rights as the best proof that his fears were well justified. Opponents organized up and down the states, and opposition came from a surprising foe, Thomas Jefferson. Many people don't realize that Thomas Jefferson was not at the Constitutional Convention in 1787 in Philadelphia and had no role in the writing of the Constitution. Thomas Jefferson was then ambassador to France and was enjoying his life in Paris. But he kept in touch with James Madison and continued to learn about what was going on in his America. Immediately upon learning of the new Constitution, Jefferson wrote back to Madison and others saying that he too feared a national government and that the first thing that should be done if the Constitution was amended is to adopt a Bill of Rights. Nationwide debate over the Constitution was widespread. People took this very seriously. Letters to the editor, as we know them today, articles were published in newspapers all over the country. Indeed, this period produced one of the most important treatises on American government, the Federalist Papers. 85 essays written by James Madison, Andrew Hamilton, and John Jay of New York argued strenuously in favor of the new Constitution. At the time, it was quite common for articles of this sort to be written anonymously, and so these essays were published under the name of Publius. Scholars have been pretty good at identifying which essays were written by which of those three great Americans. The Federalist Papers today is worth the study of any student of American history. In Virginia, Madison, who was from Virginia, realized that the Constitution was vulnerable because it lacked a Bill of Rights. Madison was an extraordinary political figure of his time. A modest man, extremely well-read, he took the notes at the Constitutional Convention, but said that they should not be published until after his death. Madison was a powerful figure in Virginia and a protege of Thomas Jefferson. Madison was a very savvy politician also. He made a promise to the people of Virginia. He said, "Ratify the Constitution, elect me to the first Congress, and I will set about the business of adopting a Bill of Rights." It was a clever and powerful argument, and indeed it carried the day in Virginia. Given the prominence and respect that Madison had, the people of Virginia were willing to trust him. Rather than calling for a second constitutional convention, they believed in Madison. Well, Madison kept his promise. The Constitution was ratified and adopted. Madison was elected to the first Congress sitting in New York City. True to his promise, he set about the task of drafting a Bill of Rights. It's said that Madison had a scrapbook of over 2,000 ideas for a Bill of Rights, that he had searched through the treatises of government, that he had searched through the declarations of rights of the various states, and that he had winnowed down those propositions and ideas to a Bill of Rights. It became 12 amendments. Remember that young sixth grader? He was absolutely right. The Senate of the United States set about debating the Bill of Rights, and they finally adopted 12 amendments. What I'm holding is a replica of the only document we know of today which we can call the Bill of Rights. This was handwritten by the Secretary of the U.S. Senate, which had adopted the Bill of Rights together with Congress. And one can inspect the document, and you will see that there are 12 amendments written on this document. The Bill of Rights, like the Constitution, had to be ratified, and so it was sent out to the individual states for ratification. The Bill of Rights was far less controversial than the Constitution had been, and so swiftly the states adopted the Bill of Rights, except for the first two, on reapportionment and on congressional salaries. The first two amendments were not adopted. And so, as that young man taught me many years ago, you have to read the Bill of Rights down to Article the 3rd to see the First Amendment to the United States Constitution. And in words which are powerful to this very day, it reads that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. On December 15, 1791, upon its ratification, the Bill of Rights became part of our U.S. Constitution. In doing so and in writing the Bill of Rights, James Madison had to overcome pressures from all sides. One argument that was extremely powerful at the time was, what if James Madison and his lofty fellow congressmen forget about a particular right? What if in their drafting they were to leave out a right which is precious and fundamental to the American people? Madison grappled with that for many weeks until he did something which is made common sense and was quite practical. It's what you or I would do if we're trying to make a list and we're not sure we've included everything. We would include a catch-all phrase. And indeed, the Bill of Rights has a catch-all phrase. The 9th Amendment to the Bill of Rights says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This is extremely important in constitutional history and demonstrates how far-sighted Madison really was. The debate has raged on to this very day. Does the Constitution of the United States limit individual rights? Does it simply set out all of the rights that belong to you and I? And if a particular right is not spelled out in the Constitution, does that mean we don't enjoy such a right? There are some who believe in the original intentions of the founders, who attempt, in my view, to have a cramped and strict view of constitutional rights. Some almost claim that we are frozen in the 18th century with the rights and liberties and technology of that time. I don't believe that's true. I don't believe that's what James Madison believed, or Thomas Jefferson, or the other founding fathers. I believe that they understood that the Constitution was a living document, that the Constitution grew with each generation. After all, none of the founding fathers could have imagined the emergence of new technology such as radio, television, and now the internet. I believe, however, that if James Madison and Thomas Jefferson and the others were alive today, they would certainly find that radio and television and the internet are part of the press, and that freedom of the press applies fully to that new technology just as much as it applied to the printing press, newspapers, and broadsides of the 1700s. And so we have a Constitution which grows with each generation. Now, if those were true originalists, if they truly were paying attention to the words and the language of the Constitution, they wouldn't ignore the Ninth Amendment. Because the Ninth Amendment specifically tells us, reaching 200 years back and to our day, that there are rights that are inherent, inalienable rights, to use the language of the Declaration of Independence. These are rights which are natural to our being. Some say they are God-given, but in a secular country we believe that they are of natural rights, rights which we are born with. Our rights are not given to us by the government. We had our rights far before there was any government in existence. We've agreed to a social contract, to form a society, to come together, and to have a government to ensure life, liberty, and the pursuit of happiness. But that does not mean that we have given up our individual rights to that government. And that indeed is why it was so important for George Mason's effort and for James Madison's work to bear fruition. Because it is the Bill of Rights which tells us, now over 200 years later, that we are protected, that these rights are guaranteed to us, and that no government, state or federal, can trample on those rights. This indeed is the work of the U.S. Supreme Court, which every day is expected to interpret the laws and the actions of government to decide whether or not they are lawful and constitutional. And so that's the wisdom of our Constitution. In creating three branches of government, the executive, the legislative, and the judicial branch, Madison knew that power had to be divided, that we needed checks and balances on government. Some have complained about gridlock, but sometimes you realize that if we didn't have gridlock, if any one part of our constitutional democracy could seize ultimate and absolute power, then we truly would have returned to that despotic tyranny that we fought the revolution to defeat. And so the president can propose laws, and Congress can adopt those laws. The president can veto them, and the Congress can override his veto. And in the end, the United States Supreme Court can determine whether those laws are constitutional. But even then, the Congress can propose constitutional amendments if they are ratified by the individual states. As you can see, each form and part of government can attempt to have its sway with public policy, but of necessity, other parts of government have the power to trump what is done. In all that process, some may think it's cumbersome and time-consuming. The truth is, I think that's just what James Madison, Thomas Jefferson, Alexander Hamilton, and the others had in mind. They almost wanted government to move slowly at times, to be sure that it didn't trample on individual rights, that no single party or faction, as James Madison warned in the Federalist Papers, would take over and would be able to control government and control people's lives. The 12 amendments that were originally proposed and the 10 amendments that were finally adopted are a true statement of the protections that all of us enjoy. Many of those amendments deal with the rights of criminals, the right to counsel, the right to due process of law, and equal protection of the law. Too often those rights are called technicalities, and people who defend those rights are stereotyped as if they are protecting criminals. Well, ladies and gentlemen, who knows who might someday be unfairly charged with a crime? And then I think a lot of people would want to have the protection of the Bill of Rights behind them and in front of them. You know, you don't need a Bill of Rights and a First Amendment when you have majority support. The Bill of Rights protects minorities. It protects the unorthodox in our society. It protects the controversial in our society. It protects minorities, whether they be religious minorities, atheists, agnostics, political minorities, social minorities, minorities of any stripe or fashion. Because after all, this government and this nation was founded by minorities. It's been fulfilled in its promise by ever-increasing numbers of immigrants and minorities who have grown and flourished in this country. We have enjoyed 200 years in this country, besmirched by one civil war, but otherwise assured of the knowledge that we can live together, different people with different beliefs, but in the knowledge and faith that our beliefs and our consciences will be protected, that we have freedom of thought, freedom of speech, freedom of the press, freedom to practice religion or to not practice religion. Eternal vigilance is the price of liberty. Let us all protect that Constitution and Bill of Rights which we adopted 200 years ago. Thank you.
We hope you have found this program intellectually stimulating and that you will continue to investigate the ideas raised here. To connect with other like-minded individuals, please contact any of the dozens of free thought organizations, such as the American Humanist Association, American Atheists, the Center for Inquiry, and Atheists United. You may also email the producer directly via leebaker27@gmail.com. This program has been distributed through the courtesy of Atheists United.